Many of you will know that if you're caught speeding, there is what some people refer to as a loophole. But it's not really a loophole, it's just a legal requirement that if it's not complied with, you ordinarily won't be prosecuted for speeding. But in this video, I'm going to explain why you should be careful with this loophole, because it's often misreferred or not referred to in full, which means you might misunderstand it and it might actually cause you more difficulty than you realize. So welcome back, I'm the Black Belt Barrister, helping you to understand law and bringing you loopholes and telling you how to be careful of such loopholes. So if you are caught speeding, it is an ordinary requirement under the Road Traffic Offenders Act of 1988 that you are notified with the intention of that prosecution within 14 days. Or it might be in person if you've been stopped. But that's a part of the loophole that I'm going to come back to in just a moment. So let's say you are caught by a fixed speed camera or even a mobile speed camera, but it's not given to you at the time. Section 1.1 of the Act requires that you are warned of a prosecution for certain offences, including speeding, within 14 days, if you were not present, of the commission of the offence. Otherwise, in the wording of the Act, a person shall not be convicted of an offence to which this section applies, where you haven't been warned of it within 14 days. However, many people will think that this means that you are required to receive this through the post within 14 days in any event, and that's not quite true. First of all, if you are stopped by the police and spoken to by the police, let's say it's a mobile speed camera and you are flagged down, or the police are behind you and they pull you over. If they warn you at the time that you've committed this offence or alleged to have committed this offence, then this will constitute a warning for the purposes of Section 1 of this Act. So it is not therefore a requirement in that particular case for you to be sent a notice through the post within 14 days. But let's go back to the situation where you are caught by a fixed camera and you're waiting for this to come through the post. Now, in the event that you do some Googling or somebody tells you that there's a legal loophole that within 14 days, if you don't receive this, then there's no way you can be prosecuted, that's still not quite true. And I'm going to give you the warning in this video that whilst in many cases it will be true and you won't be prosecuted after the 14 days, but subsection 2 of section 1 of this Act provides that a notice shall be deemed for the purposes of subsection 1c, that's sending it to you within 14 days, to have been served on the person if it was sent by registered post recorded delivery to the last known address, notwithstanding that that notice may have been returned undelivered or for any other reason hasn't been received. And furthermore, in subsection 3, it states that the requirement in subsection 1, sending you this notice, shall in every case be deemed to have been complied with unless and until the contrary is proved. In other words, it will be down to you to prove that this element has not been complied with. Now, in the vast majority of cases, the police send these out by first-class post. Now, if you receive it and there is proof that this was sent outside of the 14 days, that would be proof to the contrary, that this has been complied with under the Act. But that is still not the end of my warnings for relying on this 14-day so-called loophole in this section of the Act. The second is rather important because a lot of people don't really understand or even know about this, but the NIP, the Notice of Intended Prosecution, only needs to be sent to the registered keeper of the vehicle within 14 days, not necessarily the driver. And this 14 days only applies to that first person, the registered keeper of the vehicle. It doesn't apply to everyone after that. It doesn't apply to anyone else that might have been driving at the time of the alleged offence. So take the situation where the registered keeper identifies someone else and a further notice of intended prosecution is sent to that person, but they in turn nominate another person who was the actual driver. This is a relatively common situation, and the first 14 days only applies to the very first NIP that's been sent out. Think about cases where there's a car being borrowed, sold, hired, leased, or any of these kind of things where the registered keeper of the vehicle may not be the driver at the time. The police obligation for this NIP within the first 14 days only applies to the registered keeper of the vehicle. So if you are thinking of relying on this 14-day rule, or as some refer to it as a loophole, it's not really a loophole, it's just a legal requirement, but it has more stringent effects than many people believe. It isn't as simple as 14 days and that's it, As I said, rewatch this video so you fully understand the situation where it might not be 14 days and you may well be prosecuted for the offence. So I hope you found this useful. Please drop it a like and subscribe, and thanks for watching.